We'll be starting with the topic polity and governance today. See, basically first I'll just introduce the topic to you, and then today's class will be dedicating to some very basic concepts in polity and governance, and then most probably from tomorrow onwards we are going to start with the actual syllabus. That is, the Constitution of India is what we are going to start with from tomorrow. Now, first of all, what do you what you can say, how you are going to prepare with this very topic. So what do you expect it when it comes to the questions, the kind of questions that are asked, and secondly, how are you going to approach this very idea? Most of you are new. For the first time, either you are studying this very topic, and even if you have studied it before, that is in your academics, if you have gone through this, the approach is a bit different. That is, in civil services examination, the approach is a bit different, and till now your academics, whatever you have done there, though it helps, but it has very limited help. Clear? So there are certain things that you have to take into consideration while preparing this very topic. Now, first let us start with what are the things that you are going to read, and why I am going to suggest that I'll deal with that as well. First of all, when it comes to your prelims examination, the material that you are going to read is only one. That is a book called as M. Lakshmikant. You must have, if you have that book, that is good enough. If you don't have that book, you should buy it, and that is the sole material that you are going to read for your prelims examination. Now, sometimes the questions that you get, or in fact if you go through the previous year question papers, you would find that if you have read the book once, you might not be able to answer the question that is there in your prelims. The reason is that most of the questions that comes from in this Constitution of India, in your prelims examination, most of the question that comes, these questions are derivative in nature. That means you have a set of knowledge that you develop from going through the various provisions, various articles that you are that you read in the Constitution, and the question is basically derivative. So with that knowledge, you are going to derive an answer to that very question. Clear? So sometimes you would find, generally that is not the case. That is, on an average you would find 14 to 15 questions are generally asked in your prelims examination base, which is dedicated to this idea, Constitution of India, or polity or governance idea. And in this 10 to 11 questions are very easy. If you have the basic knowledge of Constitution, you are going to answer that. But that does not suffice. No, answering 1/3 of the questions or 2/3 of the questions in polity does not suffice. Why? The thing is that out of the 100 questions that you get, out of the 100 questions that you get in GS paper 1, on an average 15 questions would come from polity. On an average 15 questions come from polity, and out of this 15 questions you have to answer, or you have to correctly answer at least 14 of them. At least 14 of them, because this is one of the most scoring ideas. This is one of the most scoring what you can say part of your question, because otherwise if you look at it over a period of time, the questions have they have so been framed that other aspects, like if we talk about either like history, and if you see the questions that are there from history, it has become very difficult over a period of time, and the UPSC has started touching those areas which were previously not the part of your paper. So they have started focusing on, they have moved away from asking questions just on national movement, and they have started focusing on asking questions like from Buddhism, Jainism, and not easy questions. Questions have become very tough. That is also the case for rest of whatever you see. That means if you look at economics, the major part of it in your prelims examination, the major part of your questions that will be there, it would be from economics generally, the trend that that is there for the last 2 years, And if you look at the questions that are there in economics, until unless you are not just well prepared with what is, what are the basic concepts of economics, but also well prepared with what is going on currently, it becomes difficult to answer that. And on an average, you get 25 questions from economics. And not all of us are very good at, sciences or some these miscellaneous questions that comes. We are not very good at that. So that is another aspect. So what is remaining is, again, you would find geography, environment. These are the 2 or 3 topics that are remaining, and it is completely dependent upon that particular year. You would find that sometimes it so happens that questions from environment, it might be as high as 30 questions, sometimes only 3 or 4 questions. And that too, because some of you might be from, some of you are from sciences background, and that too in terms of, you have studied biology, etc. So for you, it might be a bit easier. For those who are from non-science background, it becomes a bit difficult. And all of this points out to one very clear idea. The idea is that until unless you ensure that you score 100% here, it would be difficult for you to get through prelims examination. It would be very difficult for you to get through prelims examination, and this is the kind of importance that this particular topic has. In terms of understanding, you will not face a lot of difficulties. Now, it will not be very difficult. Whatever, from today onwards, whatever we discuss, you would find that it's not that difficult. Once I explain it, once you get to know the basic idea, it's not that difficult. The difficulty is with respect to this very aspect, that you have to ensure that you score 100% in your prelims examination when it comes from polity. And you can see this trend, if you know individuals who have previously qualified prelims examination, and you ask them, out of the 15, on an average 15 questions that comes from polity, how much they have correctly answered, you would find it would be as high as either all of them, or not more than one mistake. You cannot do that. Clear? So this particular topic, the importance of this particular topic lies in this very fact, that you have to ensure that in your prelims examination you score 100% here. Now, when it comes to your mains examination, and for your prelims examination, you are only going to do, first of all, whatever we are discussing in the class, every day you have to ensure that you go back and revise whatever I have discussed. And once you revise it, you would find that it's very easy. It's not that difficult. You have to do that. And for your prelims examination, you are not going to read any other book except for M. Lakshmikant. No other book. Because see, in UPSC examinations, one of the very important part of your preparation is the fact that not only what you are going to read, but also what you don't do or what you don't read. So you don't have to waste your energy and time with going through any other book. Go through M. Lakshmikant, whatever knowledge that it covers is more than enough. And anything extra, I am going to discuss that in class. Anything extra, like you find that certain concepts that I take up in class, they are very contemporary, so it may not be there in Lakshmikant. So, but I am going to do that. That will be done in the class itself. So when we come to fundamental rights, so I'll be taking that current perspective as well. When it comes to citizenship, I'll be taking the current perspective. All these things I'll be covering in the class itself. So focus on this very idea that you first of all are able to revise whatever we discuss in the class, and then you can refer Lakshmikant, but that's it, nothing else except for the fact that yes, you are going to go through current affairs, and with current affairs from time to time there is what you can say, the importance and the relevance of certain topics differ. So in a particular year you might find, because of the kind of political scenario or because of the kind of government's decisions, some provisions of the constitution and some articles become more important than some other year. So current will provide you that perspective. It will provide you that perspective. Okay, once you are thorough with current, you know that this is this is something that is that has happened. This is something that refers to this part of the constitution. So that you understand this, I'll give you one example also. Recently, the Supreme Court came out with the Ayodhya verdict. The Supreme Court came out with the Ayodhya verdict, and in the Ayodhya verdict, it actually offered it said that the government should provide 5 acres of land for building a mosque. The question is, why did the Supreme Court do this? Why is there a need to do this? Because the court was taking a decision on a civil dispute wherein there was a part of land, it was disputed, and that the Supreme Court had the authority in that particular case to only decide about the ownership or possession of that particular land, nothing else. It was not about whether it was not about whether there should be a separate land or something like this, but the Supreme Court provided that. The Supreme Court gave that particular decision wherein it provided 5 acres of land to the All Indian Muslim Personal Law Board, and the basic idea was that there will be a mosque that would be built there. Now if you look at the decision, if you have gone through the decision of the Supreme Court, you would find the decision of the Supreme Court specifically with respect to this takes into account a constitutional provision called as Article 142 of the Constitution, which allows the Supreme Court to do complete justice, which means the Supreme Court can take up any decision, give any decision, take up any order, take up any decree so that complete justice is done. Article 142. Last year there was a petition that there was in the Rajya Sabha, the opposition parties, they wanted to introduce a resolution to impeach the Chief Justice of the Supreme Court, Deepak Mishra. The opposition party introduced a resolution, a resolution should be introduced. It went to Venkaiah Naidu, who was the obviously presiding officer, and Venkaiah Naidu rejected it. Venkaiah Naidu rejected it, and this was a question that was asked in 2019 prelims examination, a question on Judges Inquiry Act, which provides for this very provision. So every year when you go through current affairs, like an example that I have given, it does what? It ensures that you get to know what are the most important aspects of the current development in the constitution or something like that, and on the basis of it you can mold your preparation. Okay, current aspect, because these things have been in use, so I will be prepared with this. Not necessarily it is going to be asked. That is not the case. UPSC tends to specifically make sure that it does not ask anything that is very new, because it knows that very likely that most of you are prepared with this. Sometimes what they do is they ask something that is related to it. That is not necessarily that very topic, but something that is related to it. And this perspective to your preparation Now this perspective, ensuring that you get this perspective to your preparation, is what current affairs does, or no, reading the newspapers, etc. it does. It ensures that you are ready not only with the what you can say theoretical knowledge of things, but you are also ready with some contemporary ideas, and you are ready with that contemporary things. And this is something that you find very very important when it comes to your mains examination. Prelims examination, more questions are theoretical in nature, and if you have an understanding of theoretical constitution of India, that will suffice. But in your mains examination, you will find that mains examination, every question in your mains examination is not going to be as simple as that. So every question in your mains examination either has 2 or 3 parts. The first part will come from the constitution, quoting a particular article, quoting a particular decision of the Supreme Court, or quoting a particular amendment. And then the second part of the question, it would be more related to governance. That means application of that very judgment, application of that very amendment, or application of that very that very article. Like Article 142 itself. Suppose the question is on Supreme Court's power under Article 142, and in your mains examination the second part of the question is that the Supreme Court gets the constitutional power to take up judicial activism under Article 142 of the Constitution. So you can see, the term judicial activism is nowhere mentioned in the Constitution. But if we start interpreting Article 142 of the Constitution, yes, it is inherent there. The idea of Supreme Court doing complete justice. And why not? Why not the idea of judicial activism being included there? So you can see a question and the second part or the third part. The question will always have a second or the third part, and that second and the third part that would be there, it would be an application of it, or relevance of it, or some very recent idea that has happened. Like with the Sabrimala case that is going on, and the last year and the current decisions that are there of the Supreme Court, and that has raised a particular debate in India, a debate about equality versus culture. No, that debate is there. So you might get a question on this very idea, equality versus culture. Now this is where current affairs and newspapers kick in. This is what you are going to get to know once you are regularly you are going through the newspaper, you are going through current affairs. This is the perspective. This current affairs provides this perspective to your preparation. Clear? So always remember, your preparation has 2 aspects. One is the theoretical aspect, and this is the first phase of your preparation. I don't mean to say that you are not going to read newspapers, but the first phase of your preparation is always about having a good understanding and a good knowledge about the Constitution of India. Because until unless you are prepared with Constitution, you are not going to have a good idea about governance. You are not going to have a good idea about governance, because the kind of questions that are asked, women rights versus religion. Suppose you get a question on women's rights versus religion. Today we are talking about these issues, but you can see here that all these issues that are there with respect to temple entry or with respect to triple talaq or something like that, it is always, it is all the result of a patriarchal system, specifically when we talk about practices such as triple talaq, a patriarchal system. And in a patriarchal system, there is a debate that because India is a secular country, so the judiciary, the state should not tamper with these religious practices that are there. So this in itself is a question. So until unless you know what our Constitution talks about equality, what are the provisions that are there with respect to equality, and what does equality actually mean. So until unless you know that, you will not be able to write a good answer on it. Clear? So always remember, your preparation, the first phase of your preparation is about the constitution. Reading the Constitution of India well, or not the whole of the constitution, or obviously only the relevant aspects of our constitution, reading that well. So when it comes to mains examination, again the same material that you have read for your prelims examination, M. Lakshmikant, the same book is also relevant when it comes to constitution in your mains examination. There is no other book that you need to follow. There is no other book. And when it comes to the governance aspect, now when it comes to the governance aspect in your mains examination, obviously the theoretical aspects that are there, I am going to discuss those in the class, which means all those topics that are not the part of your constitution but has been mentioned in your GS paper 2, that is like citizen charter, RTI, all these topics that are there, I am going to deal with those topics as well. Clear? So theoretical part of those, because it is not covered in that book, I will be dealing with those, and you will have the theoretical knowledge of it. But again, when it comes to your newspapers, reading newspapers, reading some good articles, some good magazine, not magazine with respect to these magazines. What I am talking about is Yojana specifically. Going through Yojana, going through in such topics like very recently there was a question, there was a Kurukshetra that came, and it had this rural employment as the topic. So all these things which are a part of your syllabus, for those reading such magazines, they are more important. Remember, UPSC preparation is not just about reading books. It is not just about reading books, because there you are not going to be asked. The question that that is going to come, how you answer the question is important. Which book you have read to answer the question is not. So no one is going to ask you ever which book you have read. No, which book you have read for answering this particular question. No, it is about how you approach and how you write that particular question. So the basic once you have the basic understanding of the constitution, and you have read the current affairs, newspapers, you have understood those ideas well, that will suffice. That will suffice. Yes, for those who have a very cursory idea of what Constitution of India is, you are from sciences background, or you are an engineer and you have never read these ideas, for them I can also suggest NCRTs of social sciences, and later on political science. NCRTs are there. It is good enough. Even for those who have read it, who have this basic knowledge of constitution, etc. Even if in your graduation days you have gone through political science, you have read political science, for those also I will suggest that you should at least once definitely read the NCRTs. So it does not take a lot of time. If you go through class 6 NCRT, hardly it will take you 2 or 3 hours to read it. So that is something that you can definitely dedicate. The reason is that there are some topics, the manner in which those topics have been explained, there, they are so good. They are so good that that will definitely add up to your knowledge. Let's take an example in this so that you understand the relevance of this. In India, which was the body that was responsible for enacting the constitution? Yes, the Constituent Assembly, not the Parliament. Parliament, no. It was the Constituent Assembly that was responsible for enacting the Constitution of India. It was the Constituent Assembly that we have that had actually enacted the Constitution, and we have adopted that Constitution. It was the work of the Constituent Assembly. Clear? Now, was the Constituent Assembly an elected body? It was only partially an elected body, because the Constituent Assembly had basically 2 or 3 kinds of members. First were obviously elected members, second were nominated members or appointed members from princely states, and third were some individuals who were elected on this very idea of communal representation. That means even in the Constituent Assembly you would find that the Muslim League, initially the Muslim League that was that did get representation in the Constituent Assembly, the result of it was because of communal representation. So see, the Constitution of India, the document which we tend to regularly quote, that is not a truly democratic document. Don't you think? It is, how can we say that the Constitution of India, which is the result of a body, the body which was not an elected body, it was only a partially elected body, not a completely elected body, how can we call that particular this body, and how can we allow them to frame the Constitution of India? And the manner in which it is explained in the NCRTs, that though we criticize the Constitution, and the very idea of Constitution has been criticized, that it was not the result of an elected body, but it is said that Constitution, it specifically mentions that representation has 2 aspects. The idea of representation has 2 aspects. One aspect is voice and the other aspect is concerns. Voice means the language that is used by an individual who is elected, and the obviously concern means the individual who is elected takes up those issues that are relevant for the people. So yes, this was not the case. That means generally the language that was used in the Constituent Assembly was English, and that was not the language of India. But when it comes to even the members of princely states, if you go through the debates, discussions of the process, and discussion of each and every aspect, each and every article, and what were the debates, what were the issues raised by each and every member of the Constituent Assembly, you would find even those members who were appointed, who were nominated, who were not elected, who were representing the princely states, but when it actually came to what was the voice and concerns that they raised there, it was the concerns of the people at large and not the concerns of a ruler. And that is the reason why even this criticism of the Constituent Assembly does not stand, that it was not a representative body. And such various such aspects are mentioned in the very such ideas are mentioned in the NCRTs. Like if I tell you to describe democracy, how would you describe democracy? No, you will say for the people, by the people, and of the people. Now when you say for the people, by the people, and of the people, what is the mechanism to ensure for the people, by the people, and of the people? Elections. Which means if I tell you that a country which regularly takes up elections, is that a democratic country? By this logic the answer is yes, that any country which regularly takes up elections automatically becomes a democratic country. But actually this is not the case, and elections are not the precondition, the only precondition for a democratic country. There are number of other things like elections. What is the nature of elections? It should be free and fair. Who is the ruler? Who is the ruler accountable to? All these things are there, and all these things are very well described in democracy. Now, in your NCRTs, if you go through this, you will understand this. And that is the reason why I always tend to recommend that, whenever you feel, if you think, okay, reading for UPSC sometimes tends to be a lot of very tiresome. So if you're tired and you feel like, I need to read something light, not something very heavy, which happens very frequently, go through NCRTs during that particular period. And first of all, it is interesting because there are number of examples that are given. You tend to come to know certain things which you have not previously known. And that is something that is going to help you a lot, even in the kind of language in which you are writing your answers. So you are going to just add here the NCRTs, except for it, the preparation in terms of what you read is very traditional. Everyone is, if you ask any individual, they are going to tell you the same thing. ठीक है, अगर मुखर्जी नगर में किसी चाय वाले से भी पूछोगे ना, तो उनको भी नाम पता होगा एम लक्ष्मीकांत का. तो that is very traditional, but the way you read it is important. And here comes the importance of previous year question papers. You should always have them to understand what is relevant and what is not. Now, what is relevant and what is not, because even Lakshmikant, if you look at the book is a thick book. It's not that easy to read each and every page of it. So even in that very book, what are the things that you need to skip? What are the things that you need to go through? Once you go through the previous year papers, you indulge in this exercise, reading, referring to class, reading the book M. Lakshmikant, also going through the newspapers, going through the previous year question papers. Now what happens is you get the knack of this particular examination. Otherwise, if you don't get the knack of this examination, you will always be playing a catch-up game. UPSC के साथ ये होता है, आप पूरे के पूरे प्रिपरेशन में कैचअप गेम खेलते रहते हो. मतलब जब यूपीएससी ने क्वेश्चन पूछ लिया फिर वो पढ़ना शुरू करोगे, अदरवाइज नहीं पढ़ोगे. ये होता है बहुत लोगों के प्रिपरेशन में. आप देखोगे, दिस इज वन ऑफ द वेरी इंपॉर्टेंट एस्पेक्ट्स. दे टेंड टू गो थ्रू समथिंग ओनली व्हेन यूपीएससी हैज आस्क्ड अ क्वेश्चन ऑन इट, बट वो रिपीट नहीं होता है. और फिर अगले साल कुछ और नया आता है, अगले साल कुछ और नया आ जाएगा, और वो हमेशा वो कैचअप गेम चलता रहेगा कि इस साल ये पढ़ा, नेक्स्ट ईयर दिस, नेक्स्ट ईयर दैट, एंड दैट इज नॉट हाउ यू सक्सीड. So you have to get the knack of what are the questions that are being asked, and you have to be preemptive about it. That okay, this is something that can be asked. Always in that particular mode, when you are going through your traditional or you're reading the newspaper, you should always have this knack of trying to visualize that okay, this can be a question and how can this be asked. Once you do that, now then you would find that it becomes predictable. Now then UPSC examinations are predictable. Otherwise it is not. So once you get the knack of it, so you'll find okay, this is a question that is likely to be asked. You presume that okay, this might be the manner in which it is asked, and you would find the same question is asked in your mains examination or your prelims examination, and that is how you succeed. Clear? So always remember, always in this mode of constantly, whatever you are reading, constantly you should be in this mode of trying to ask yourself as to what kind of question can be asked from this very topic, and trying to what you can say, proactively construct for yourself a question that is to be asked. And after some time, start writing on it. That okay, this is, once I have read through this topic, this is a question that might be asked. You take up a question, you write by yourself, and that is the best way you prepare. That is the best way you prepare, and once you do this, you would find the the whole very idea of at least this topic polity governance, it becomes a bit easier. अगर आप चारों जीएस के पेपर को कंपेयर करते हो, जीएस पेपर 1, 2, 3 and 4, आउट ऑफ दिस यू वुड फाइंड दैट जीएस पेपर 2 में लीस्ट स्कोर आता है. On an average, this is the least you get here, GS paper 2. इसका एक रीज़न है. इसका ये रीज़न ये है कि जनरली आपको ये लगता है कि आप सही लिख कर आए हो, but what you write and what the question is, what is expected out of you are two different things. So that when I say the knack of getting to the questions, this will involve this also. Trying to understand what is the exact requirement of the question. Because आपने मान लो, जैसे मैंने आपको एग्जाम्पल दिया, आपने आर्टिकल 142 देखा और आपने आर्टिकल 142 के बारे में लिख दिया, बट द एग्जामिनर विल गिव यू गुड मार्क्स ओनली व्हेन द एग्जामिनर फील्स दैट यू हैव रिटन व्हाट इज एक्चुअली रिक्वायर्ड. If you write something that is related but not required, now you will get marks, लेकिन वो कम हो जाता है. You will find you are getting your scoring 60, 70 out of 250. This happens. आपको ऐसा लगता होगा कि 100 लाना बड़ा आसान है, ऐसा नहीं है. If you score 100, 125 in all your four papers, you are going to top this examination. 50% स्कोर करोगे तो आप तो टॉप कर जाओगे ना एग्जामिनेशन. इवन इफ यू स्कोर 45%, यू वुड बी अंडर 50. योर रैंक इज अंडर 50. ऐसा क्यों होता है? वाई 45%? क्योंकि हमें जिस तरीके से ट्रेन किया जाता है ना, व्हेन वी आर एक्चुअली इन आर ग्रेजुएशन एंड पोस्ट ग्रेजुएशन, हमारा ट्रेनिंग इस तरीके से होता है आंसर लिखने का, दैट वंस आई गेट टू नो, ओके एक क्वेश्चन मुझे नजर आ गया, Now this question has this very idea, और मैंने उसके बारे में जितनी चीजें पढ़ी आज तक मैं सब लिख दूंगा. That is not how it works in UPSC. Clear? So this should be from the very first day, this should be something that you should know, that okay, these are the requirements that are there, otherwise you are going to make mistakes. Clear? Absolutely clear. So whenever, at least in this paper, whenever you are going through any particular topic, once you are, suppose you are framing a question or you have come across a question and you are writing the question, don't write what you know, write what is required. Clear? And what you know is from, it is the very idea, it is the very source wherein you derive what is required. उसी चीज को डिराइव करोगे वहीं से. लेकिन प्रॉब्लम क्या है, दैट इफ यू डोंट फोकस ऑन दिस आइडिया एज टू व्हाट इज रिक्वायर्ड, देन यू आर गोइंग टू राइट व्हाट यू नो, नॉट व्हाट इज रिक्वायर्ड. फ्रॉम द वेरी फर्स्ट डे स्टार्ट फोकसिंग ऑन दिस. क्लियर? So these are certain things that you should know. Before I get into these ideas, you should from the very first day know these things. Clear? Yes. Yes. From 6, class 6. कुछ ऐसे सिंपल चीजें जो बहुत क्लास 6, 7 के NCERTs में आपको मिल जाएंगे. Like when we talk about the description of political parties. Now you'll find it is mentioned in one of the books in NCERTs, and in the course of our discussion we are going to discuss pressure groups. Later on, you would find that the definition of pressure group and political parties are very similar. Until unless you know the exact difference, it is difficult. Clear? Yes, you can. कुछ ऐसे topics हैं जैसे उनको पढ़ने की जरूरत नहीं पड़ती है. Like you would find in your topic parliament, ठीक है, पार्लियामेंट में यूथ पार्लियामेंट का एक टॉपिक, इट मेक्स नो सेंस गोइंग थ्रू इट. वो क्यों इंक्लूड किया गया था वो भी बता देता हूँ. 2009-10 में जाओगे ना, प्रीलिम्स एग्जामिनेशन में यूथ पार्लियामेंट से एक क्वेश्चन पूछा गया था, इसीलिए उन्होंने पूरा का पूरा टॉपिक इंक्लूड कर दिया. ठीक है. नाउ लेट्स स्टार्ट टुडे. दिस इज व्हाट यू शुड ऑलवेज कीप इन माइंड. आई ऑलवेज give somewhere around half an hour, 45 minutes to this. so that in the next whatever we are going to discuss, until unless you start from the very first day focusing on this, आपके preparation में और किसी एक इंडिविजुअल के प्रिपरेशन में जो शायद इस एग्जामिनेशन को क्लियर नहीं कर पा रहा, कोई फर्क नहीं रह जाता है. ठीक है. Let's start with this idea, constitution. As I said, today only I'll dedicate to the basics. What are the basics? What do you mean by what do you think is constitution? The constitution. Rules and regulations. Rules and regulations on which, as she explains, a country should work on certain principles. Okay, rules, regulations, certain principles. Anything else? Anything else that you can add here? If constitution is only a set of rules, regulations and certain principles, in that case there are certain countries which have an unwritten constitution. What do you think? Those countries work without rules and regulations? No. So the constitution might be something else as well, something, no, if we talk about, let's take an example. Let's take an example of a country like UK. UK does not have a written constitution. When I say written constitution or no, an unwritten constitution, what does that mean? Written constitution, like India having a written constitution. So you would find that there is a book called as the Constitution of India, and in that case you would find various provisions like Article 142, Article 1, 2, 3, 4, schedules, certain amendments that can be done to this very book or these provisions that are there, which means we have a constitution, a written constitution, and this means that there is a one codified book or one codified document that comprises of various provisions. That is not the case when it comes to UK. Unwritten constitution does not mean the constitution is not written. It simply means that the constitution has not been codified into a single document. The constitution has not been codified into a single document. So you would find there what happens is any law that is passed by the parliament there, it automatically becomes the part of the constitution there. Similarly, there are something called as statutes or also called as judge-made laws, which means when the judiciary pronounces a decision, it automatically becomes the part of the constitution. That is what is meant by written and unwritten constitution. And that is the reason why I say that if you say the rules and regulations, can we say that Constitution of India is a simple, rules and set of rules and regulation, or is it more than that? It is more than that. So why is it more than simple rules and regulation? It mentions certain rights and duties. Okay, the Constitution talks about certain rights and duties. So just because the Constitution mentions certain rights and duties, it is more than what a law or what an unwritten constitution is. It is protected by the judiciary. What do you mean by that? It is protected by the judiciary. There to have checks and balances, yes. See, more appropriately, what she is trying to say, she is absolutely correct, and that is the very reason why constitution is more than just simple being rules and regulation. What is she trying to say? She is trying to say is that Constitution of India is the supreme document, or any constitution, any written constitution becomes the supreme document, which means that this is the highest law. Now, why is the constitution the supreme document, or the constitution the highest law of the land? The supreme, it is the supreme document or the highest law of the land because the constitution is generally protected by the court, and it is the court which guarantees the supremacy of the constitution, which means, see, if constitution was simply some rules, regulations, which would mean that an additional rule and regulation, or some adding or subtracting a rule and regulation might change what the constitution prescribes, but that is not what happens. For other rules and regulations, or for that matter, simply speaking, if there are some other laws that are made by the parliament, that are enacted by the parliament or the state legislatures, those laws to remain enforceable, that means to remain in force, those laws are to abide by the book or abide by this document called as the Constitution of India. Why? Because the Constitution is the supreme document. As you have already mentioned, it considers certain principles. More appropriately, it considers, or it has some basic principles. The basic principles or the basic philosophy. The basic philosophy of that particular country. The basic philosophy of that particular country. How can you know what is the most objective way to judge whether a country follows what kind of principles? What is the most objective way to judge it? Look at the constitution of that particular country. India is a democratic country. We say India is a democratic country. Why do we say this? Why do we say India is a democratic country? Why do we say India is a secular country? Why is it, why would we say that in India the judiciary is autonomous? There is separation of powers, something called as separation of powers. We say this because all these things are the part of the basic philosophy or the basic principle that is mentioned in a document called as the Constitution of India. Similarly, if you look at some other countries and if you look at the basic philosophy on which the country is governed, that basic philosophy is always mentioned in the constitution of that particular country. Like if we talk about the Constitution of China, Article 127 of the Constitution of China says the judiciary is the part of executive. So it does not say the judiciary is autonomous. It does not say that. It says judiciary is the part of the executive. Which means the judiciary does not come up with decisions which go against the executive. Judiciary does not do that. So judiciary is not there in a country which does not have separation of powers, in a country which does not have autonomy of the judiciary. How can we say the country will provide for basic rights to the citizens? That is not the case, and at any given point of time the executive might take away certain rights and the judiciary will do nothing about it. That is not the case in India. So we do not consider China to be a country which protects the rights of the citizens. We do not consider, you just described democracy as what? As for the people, by the people, of the people. So how can China be a democratic country? It cannot, because a country which does not provide rights to the citizens, rather these rights are concentrated with the state. How can that country be a democratic country? That is not the case. On the contrary, if you look at a country like US, and if you look at the basic philosophy of the constitution there, again it would point out to these very ideas. So when we say what the constitution is, the constitution is a set of principles, the basic philosophy of governance of that particular country, or the basic philosophy on which the governance of that particular country is based. Not only that, and yes, the constitution also talks about rights and duties of the citizens. Like when we talk about fundamental rights, when we talk about fundamental rights, so what is it? It provides certain rights to the citizens of the country. Against whom? Against the state. Absolutely correct. So what are the rights that we have? We have these fundamental rights. These rights are available to us. Most of these rights are available to us against the state. So how can you describe a right? Right is, whenever we talk about rights, rights are certain duties that the state has towards its citizens. Clear? So what are duties then? Rights of the state. What are duties then? So duties are nothing but certain rights that the state has. Against whom? Against the citizens. Certain rights. If India is at war, being a citizen of India, I can be forced to take up war. To fight for my country. I can be forced to do that. Why? Because it is the right of the state. It is the duty of a citizen. Clear? So not only does it all provide for rights and duties, but the constitution also provides for it establishes the political structure in a country. It establishes a political structure in the country. Now, when we say India, what kind of democracy is India? Yes? Federal is not a democracy. Yes? No. India is a parliamentary form of democracy. पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट है ना, एक पार्लियामेंट एग्जिस्ट करता है, एक पार्लियामेंट इज एक्टिंग लाइक अ लेजिस्लेचर. व्हेन वी से पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट, द क्वेश्चन इज हाउ इज इंडिया अ पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट? Because it is mentioned in the Constitution of India. It is mentioned in the Constitution of India. If you look at Article 80, Article 81, Article 80, 81 talks about two houses, the Rajya Sabha and the Lok Sabha. It talks about two houses, Rajya Sabha and the Lok Sabha. Article 74 of the Constitution talks about the Council of Ministers headed by the Prime Minister to aid and advise the President. Article 75 of the Constitution says the Council of Ministers are collectively responsible to the Lok Sabha. This makes us a parliamentary form of government. The provisions of the Constitution establish the political structure. If you look at Article 1, 2, 3 of the American Constitution, you will understand what kind of political structure has been established there. Article 1 of the Constitution of America talks about separation of powers. Article 2 of the Constitution of America talks about a presidential system. It mentions there shall be a president who will head the executive branch of the government. It mentions there. So it is the Constitution which establishes a political structure in the country. Similarly, the Constitution also establishes the other wings or other branches of the government. Article 52 of the Constitution of India says there shall be a president who will be the head of the state. Article 53 of the Constitution says the powers of the union will be in the hands of the president, and he shall exercise any such powers in accordance to the Constitution of India. Legislature, as I said, Article 80 and Article 81 of the Constitution talks about two houses of the Parliament. Article 124 of the Constitution talks about Supreme Court. Article 215 of the Constitution talks about High Court. All of these provisions are mentioned where? In the Constitution itself. So, an executive, the legislature and the judiciary, these bodies have been established where? These bodies have been established by the Constitution of India itself. Not only are these bodies established by the Constitution, but also the duties, the powers, the duties and the functions these bodies have are also mentioned in the Constitution itself. You would find that the Constitution of India it says what is the power of the executive. It talks about what is the power of the judiciary. Article 142 we have just discussed. Similarly, you would find when we discuss Article 129, 130, 131, all these deals with appellate jurisdiction, original jurisdiction and the what you can say advisory jurisdiction, etc., etc., jurisdiction of the Supreme Court. Similarly, there are provisions with respect to that for the High Court. Similarly, there are some powers that are mentioned that the Lok Sabha has. Similarly, there are certain powers that are mentioned that the Rajya Sabha has. Similarly, is the case with the Council of Ministers. So, what powers and functions are performed by these structures are also mentioned in the Constitution itself. Not only does the Constitution just mentions the powers, duties and functions, but it also mentions the limit to such powers, duties and functions. What are the limitations on such powers, duties and functions are also mentioned in the Constitution itself. जब Constitution में ये explicitly लिखा हुआ है that the Council of Ministers will do this or the President will have such powers, जब वो चीजें उसमें explicitly mentioned हैं, इसका मतलब क्या है? इसका मतलब ये भी है, it also means that something that is not mentioned as a part of their duties, powers and functions are not under the jurisdiction of the concerned authority. Article 262 of the Constitution says, Article 262 of the Constitution says that when it comes to the jurisdiction of sharing of rivers and river valleys, in that case, Parliament through a law can exclude it from the jurisdiction of the Supreme Court. Supreme Court भी उस पे judgment नहीं दे सकता है अगर कौन चाहे? Parliament of India. By mentioning this Article 262, what is the Constitution doing? It is describing or it is defining what powers does the Parliament have. Not only is it defining what powers does the Parliament has, it is also putting limitations to the powers that the Supreme Court has. So not only does the Constitution describe or the states powers, duties and functions of such authorities, it also does what? It also ensures that it provides for limits to such powers, duties and functions. Clear? All in all, what can we say? हम ये कह सकते हैं एक सेंटेंस में अगर हमें कॉन्स्टिट्यूशन ऑफ इंडिया को डिस्क्राइब करना है, वी विल से it is the fundamental law of the land. It is the fundamental law of the land. Clear? Why? Because the Constitution is supreme and the Constitution talks about all these ideas. It becomes the fundamental law of the land. And This fundamental law of the land is also described as an organic document. What does this mean? Organic document? Yes? क्या होता है मतलब? No. Organic law, it is considered to be an organic law because it evolves, it changes, and it can be done. That means the constitution within itself talks about how it can be amended. और इसी वजह से आप देखो, if we go back to the year 1950, हमने कॉन्स्टिट्यूशन ऑफ इंडिया इम्प्लीमेंट किया 1950 में. टुडे वी आर ऑलमोस्ट इन 2020, विच मीन्स 70 years, 70 साल हो गए हमें, और फिर भी हम उसी डॉक्यूमेंट के साथ कंटिन्यू कर रहे हैं. If we did not have the power to amend, or if it was not an organic document, in that case, how could the document still be relevant? How could the document still be relevant? Because things have changed. 1950, 2020, we cannot compare. We cannot compare the 1950 with 2020. There are so many environmental changes that have happened. But still, that same document, we are continuing with the same document. Why? Because this document evolves. It's not a static document. It is a dynamic document. It evolves. And this evolution, who contributes to this evolution? Who contributes? Who amends the Constitution of India? Yes. Officially or formally, the Constitution of India is amended by only one institution, that is the Parliament. But there is also some unofficial, or what you can say, informal amendments done. And who does that informal amendments? The courts. The Supreme Court and the High Court. They have the power of judicial review. Under Article 13, under Article 32, under Article 226 of the Constitution, these bodies have the power to review, and thereby from time to time they tend to do what? They tend to contribute to the evolution of this particular document. एग्जाम्पल से समझते हैं. अगर कोई कंफ्यूजन है तो एग्जाम्पल से समझ लेते हैं. देखो, फॉर्मल अमेंडमेंट में सिंपल से ये समझ लो, लैंग्वेज चेंज हो जाता है. ठीक है, देयर इज अ प्रोसेस, एन अमेंडमेंट एक्ट इज टेकन अप. Informal amendment means that though the body, Supreme Court, does not have the power to amend the Constitution, it has the power to interpret the Constitution. And through interpretation, it does what? It tends to evolve. This document evolves. Example देखो ना, Article 21 of the Constitution. What is Article 21 of the Constitution? It talks about right to life and personal liberty. ठीक है? Right to life and personal liberty. If you see that since the year 1950, or if you go back to the judgment of the Supreme Court in the year 1950 on the interpretation of Article 21, and if you come to very recently 2017, Supreme Court's interpretation of Article 21, in this particular time of almost 67-70 years, the whole nature of Article 21 has undergone a change. क्या language में change हुआ है? नहीं. There is no change in the language. The Article 21 reads the same today as it read in 1950 when we adopted the Constitution. There was no change. Today also it says that the state cannot deny an individual of his right to life and personal liberty except for a procedure established by law. ये लिखा हुआ है Article 21 of the Constitution. But today, if you look at what the term right to life actually means, it has undergone a change. पहले एक समय राइट टू लाइफ का मतलब यही था, राइट टू सर्वाइवल, राइट टू प्रोटेक्शन ऑफ योर बॉडीली पार्ट्स. दैट इज व्हाट आर्टिकल 21 meant. But today The Article 21 of the Constitution includes right to privacy. It includes right to a livable environment. All these things, there are number of ideas that have been included there. It is also an amendment. It is also an amendment, but it is not a formal amendment. It is more like an interpretation, an evolution. So more appropriately, rather than understanding it as an informal amendment, you can understand it in this manner, that the courts also contribute to the dynamic nature of Indian Constitution, and they allow, through their judicial interpretation, they allow the Constitution of India to evolve. And that is the reason why today also this body is a relevant, this document is a relevant document. एक तरफ हम कॉन्स्टिट्यूशनल अमेंडमेंट्स करते हैं, जैसे हमने 101st कॉन्स्टिट्यूशनल अमेंडमेंट कर दिया, 100 अमेंडमेंट कर दिया, 99th कॉन्स्टिट्यूशनल अमेंडमेंट कर दिया, एंड थ्रू दिस अभी आपने 104th कॉन्स्टिट्यूशनल अमेंडमेंट के बारे में पढ़ा होगा, एंड थ्रू दिस व्हाट वी डू इज वी मेक फॉर्मल अमेंडमेंट्स, एंड थ्रू दिस वी ट्राई एंड मेक द बॉडी मोर एंड मोर, द डॉक्यूमेंट मोर एंड मोर रेलेवेंट. तो हमने जो हमारा 1950 में जिस तरह से टैक्सेस को गवर्न किया जाता था सेंटर स्टेट के बीच में, आज वो कंप्लीटली चेंज हो गया है. आज जीएसटी काउंसिल एग्जिस्ट करता है, and it is the GST council which decides this. Previously this was not the case. It was an autonomy of the states. States decided क्या होंगे टैक्सेस के रेट etc etc. But now it is the GST council making it more relevant through various changes, formal changes, like coming up of the idea of GST, like looking at the contemporary socio-economic nature or situation of the country. What have we done? We have included something called as reservation. We have given reservation to economically backward section. This does what? This makes the document more relevant for the contemporary governance. Otherwise it would have been an obsolete document, khatam ho jata. But that is not the case. That is not the case. इंडिया में ये नहीं होता है. अमेंडमेंट्स किए जाते हैं फॉर्मल, एंड देन देयर इज एवोल्यूशन ऑफ द आइडिया, एंड दैट एवोल्यूशन इज डन थ्रू इंटरप्रिटेशन, जुडिशियल इंटरप्रिटेशंस, एंड दैट इज डन बाय द सुप्रीम कोर्ट एंड द हाई कोर्ट. दे ऑल्सो इंटरप्रेट द डॉक्यूमेंट. इंटरेस्टिंगली देखो, हम इस कॉन्टेक्स्ट में इस बात को समझो. अगर हम फ्रांस की हिस्ट्री देखते हैं, France has adopted for 9 constitutions. Constitution ही बदला है उन्होंने. They have opted for 9 constitutions. India is doing with only 1. उसी से काम चल रहा है हमारा. हमें जरूरत नहीं है, हमने 9 constitutions बनाने की जरूरत नहीं पड़ी हमें. क्यों? Because of this very reason. So it's a dynamic, it is an organic document.
Sir, are they equally enforceable?
Yes.
Are they equally enforceable?
Some of them are. Not everything. Not every idea. Not every interpretation of the court becomes. Not every interpretation of the court becomes equally enforceable. But when the court reviews an idea and gives a decision, when it is an order, it is a decree, then it becomes enforceable. ठीक है. कुछ ऐसी चीजें होती है जैसे राइट टू प्रिवेसी की अगर हम बात करें, 2017 आपको पता होगा, देयर वर लॉट ऑफ आइडियाज अबाउट प्रिवेसी रिलेटेड प्रॉब्लम्स, और अकॉर्डिंगली जो है वी हैव कम अप विद सम प्रिवेसी रिलेटेड लॉज, प्रिवेसी रिलेटेड डिसीजन. सुप्रीम कोर्ट केम अप विद अ प्रिवेसी रिलेटेड डिसीजन सेइंग दैट राइट टू प्रिवेसी इज अ पार्ट ऑफ फंडामेंटल राइट अंडर आर्टिकल 21. लेकिन ये एनफोर्सेबल कैसे है? नहीं है ना ये एनफोर्सेबल. आप खुद ही सोचो ना, व्हाट इज प्रिवेसी? सुप्रीम कोर्ट ने तो कह दिया कि इट इज पार्ट ऑफ फंडामेंटल राइट, लेकिन प्रिवेसी का मतलब क्या है? इज इट लीगली डिफाइंड? नहीं. until unless we define it legally, how can it become enforceable? ठीक है, जब तक कोई लीगल डेफिनेशन नहीं होगा तब तक वायलेशन. नो, व्हाट इज एनक्रोचमेंट ऑन प्रिवेसी, व्हाट वुड बी वायलेशन ऑफ प्रिवेसी, इस तरह की चीजें हम कैसे डिफाइन करें? सुप्रीम कोर्ट ने कहा फंडामेंटल राइट का पार्ट है, बट इट बिकम्स नॉन एनफोर्सेबल. व्हाई? बिकॉज देयर इज नो लीगल डेफिनेशन टू इट. ठीक है, हैव यू अंडरस्टूड? So Constitution of India 2019, this was a question 2009 this was a question asked in mains examination. ठीक है, व्हाट इज कॉन्स्टिट्यूशन ऑफ इंडिया, ठीक है, एक सिंपल सा क्वेश्चन था, मार्क्स सबको बेकार आए थे क्योंकि सबने जो लिखा था ना एक पेरोकियल अंडरस्टैंडिंग से होता है. यू हैव टू अंडरस्टैंड व्हाट आर द थिंग्स दैट यू आर गोइंग टू राइट. यू आर गोइंग, इफ यू राइट दीज आइडियाज यू आर गोइंग टू गेट मार्क्स बिकॉज दिस इज व्हाट द कॉन्स्टिट्यूशन इज. ठीक है, नाउ in this we had talked about this idea, establishes the political structure, establishes the kind of branches of the government. It talks about duties, functions and limits. In this context, let us understand a very important idea called as separation of powers. Give this subheading, separation of powers, very important. See, till now whatever I have discussed, have you understood this? ठीक है, there is no problem because if in the initial few days I would like to be a bit slow, तो मैं थोड़ा time दे रहा हूँ, I am explaining every idea, but after some basics you'll start getting knack of the way I tend to go about things, तो आपको थोड़ा सा आदत हो जाएगी. ठीक है, but initially if you face any problems with respect to my the way I speak or language or for that matter my pace, ठीक है, तो आप मुझे बता देना. Clear? Separation of powers. The idea of separation of powers has been given by an individual a French philosopher, Montesquieu. Montesquieu gave this idea of separation of powers. Clear? So Montesquieu gave this idea of separation of powers. Now separation of powers between whom? Separation of powers between the three organs of the state or the three branches. That is the executive, the legislature and the judiciary. Now, what is the idea and what is the objective of it? The idea and objective of separation of powers, it rests upon the historical ideas of or historical if you look at the history of France and England, you would find this. The reason or the why Montesquieu forwarded this concept of separation of powers. देखो, France and UK were basically a monarchic system. Even today British monarchic ही हम कहते हैं, monarchic because the head of the state is is basically the king or the queen. ठीक है, एक institution and that is hereditary in nature. So today also UK is a monarchic system. France is no more, but UK was is a monarchic system. France was a monarchic system. Monarchy में क्या होता है? एक इंडिविजुअल है या एक इंस्टीट्यूशन है कॉल्ड एज द किंग. एक इंस्टीट्यूशन है कॉल्ड एज द किंग और उस इंस्टीट्यूशन के पास सारे पावर्स हैं. उस इंस्टीट्यूशंस के पास सारे पावर्स मतलब किंग ने जो कह दिया वो लॉ. ठीक है, किंग ने जो कह दिया वो लॉ, उसे इंप्लीमेंट कैसे करना है, इट इज बेसिकली डन बाय द ब्यूरोक्रेसी. उस समय भी ब्यूरोक्रेसी एग्जिस्ट करती है. इट वॉज ब्यूरोक्रेसी कंप्राइजेज ऑफ पीपल हु वर क्लोज टू द किंग. ठीक है, इट वॉज नॉट एन अपॉइंटेड और पूरा मेरिट सिस्टम नहीं चलता था, लेकिन ब्यूरोक्रेसी कंसिस्ट ऑफ दोज इंडिविजुअल्स हु आर क्लोज टू द किंग. बट हु इज द हेड ऑफ द ब्यूरोक्रेसी? अगेन द किंग. एंड इफ as an individual or as a subject I have a problem with the law or with what king has to say or with the manner in which it has been implemented, in that case who is the highest court of appeal? The king. यानी किंग ही लॉ बनाता है, किंग ही लॉ इंप्लीमेंट करता है, और अगर किसी तरह के ग्रीवांसेस हैं या इंटरप्रिटेशन की जरूरत है वो भी किंग ही करता है. दिस मेक्स और दिस लीड्स टू व्हाट? दिस लीड्स टू concentration of powers. Concentration of powers in a body, that is the king. And this does what? It leads to existence of an absolute or arbitrary absolute or arbitrary power. That means the power that king has, it is absolute. No one can challenge what the king has to say. No one can challenge the manner in which what laws have been made, how can it be implemented. And if we need, if we have grievances, subjects have grievances over what has been said by the king, in that case we have to appeal again to the king himself, which means that the power that the king has is absolute, and absolute power is arbitrary in nature. हमेशा याद रखना, absolute power is arbitrary in nature. It makes the state a tyrant. ठीक है, एक absolutist state क्या होता है? Tyrant होता है. Tyrant मतलब जिसमें जहां पर इंडिविजुअल्स के पास, सब्जेक्ट्स के पास राइट्स नहीं है, उनके राइट्स को बार बार स्टेट जो है उनके राइट्स, द स्टेट डिप्राइव्स देम ऑफ देयर राइट्स. दैट काइंड ऑफ अ स्टेट. इफ वी डू नॉट हैव if we have existence of arbitrary and absolute power, there is a phrase, power corrupts and absolute power corrupts absolutely. ठीक है, so power corrupts and absolute power corrupts absolutely, and that is what we see here. And to ensure that this does not exist, the Montesquieu says that three organs of the state that are there, there should be division, that is legislature, executive and the judiciary. And these bodies should have separate responsibilities, like the legislature being responsible for law making, legislature being responsible for law making, executive being responsible for law implementation, and judiciary being responsible for law interpretation. लॉ इंटरप्रिटेशन मतलब लेजिस्लेचर ने लॉ बनाया, एनैक्ट किया, जब लॉ को इंप्लीमेंट करने की बारी आई तो लेजिस्लेचर ये काम नहीं करेगा. दिस वुड बी द वर्क ऑफ अ डिफरेंट बॉडी, अ डिफरेंट ऑर्गन, दैट इज द एग्जीक्यूटिव. एंड if I appeal against the law, that means if I do not, I feel that the law has been enacted in such a manner that it has deprived me of my rights, or if the law has been executed in such a manner that it has deprived me of my rights, I can appeal to the judiciary. So I will not be appealing to the legislature, the institution that has enacted the law, क्योंकि उन्होंने तो enact किया है. अगर उन्होंने enact किया तो वो कैसे मानेंगे कि उन्होंने जो law enact किया वो मुझे मेरे rights को deprive करता है. That would not be the case. And similarly, because the executive is responsible for execution of the law, and hence a separate body which has nothing to do with either the law enactment or law implementation, is responsible for what? Is responsible for law interpretation. Also can be understood as grievance redressal. Also can be understood as grievance redressal. So by separating these, that means why coming up with three organs and separating these, what these organs do, Separating what these organs do, what is the objective Montesquieu has? To prevent the state from becoming absolute or a tyrant. Arbitrary, there will be no arbitrary powers. There will be no arbitrary powers if you divide the whole idea of how law is enacted, implemented. Similarly, legislature would only enact the law, no influence on the law in implementation or law interpretation. Similarly, executive will only implement the law, no influence on law making or law interpretation. Clear? Strict, watertight separation of powers. Clear? However, the first country to introduce this idea of separation of powers is US. They for the first time included this idea of separation of powers in their constitution. In their constitution, they included it for the first time. However, when they included the idea of separation of powers in their constitution, along with separation of powers, they also included something called as checks and balances. Along with separation of powers, they have included an idea of checks and balances, which means the strict separation of powers or the watertight separation of powers advocated by Montesquieu, it has been innovated upon by US, by the constitution of US, by the constitution makers there. They have innovated here and they have added the idea of checks and balances along with the idea of separation of powers. What is meant by checks and balance? Checks and balance, the idea or the principle of checks and balance simply means that the legislature would enjoy some control over the other two bodies, and similarly the executive will enjoy some control over the other two bodies, and similarly the judiciary would also enjoy some control over the other two bodies or the other two organs. The idea of checks and balances. Now, how does this work? How does this idea of checks and balance work? Now, how does it work? If you see, if we talk about the legislature is responsible for law making, and through law making or law enactment, they can basically guide how the executive works or how the judiciary works. How the executive works or how the judiciary works. Like you would find that the legislature defines what is the qualification of an individual to become a member of the judiciary. There can be a law enacted. The process can be taken up through a law. Similarly, the legislature can also determine how the executive is going to implement certain laws. Let's take an example. Have you heard about an instrument called as the budget? What is budget? Through budget, legislature sanctions the kind of money that executive will have to implement various policies and programs. Which means what? The legislature can at any point impose certain limits to it. Not more than this. Budget says, suppose Manrega has to have, suppose 50,000 crores. Or you must have heard about a scheme called as Ayushman Bharat scheme. Suppose Ayushman Bharat scheme, the money allocated to this to implement this scheme is suppose 50,000 crores, which means not more than that. It is the upper limit on which the executive can take up. What is the investment there is that it can do? Thereby doing what? By coming out with upper limit, thereby what is the legislature doing? The legislature is guiding or controlling the executive, ensuring that executive works other the, with what you can say within the parameters of a law, which we call as the budget. Similarly, the legislature can enact a law, and through the law what the legislature can do? The legislature can guide the working of the judiciary. Example, have you heard about something called as a National Judicial Appointments Committee? There was a constitutional amendment that was done in 2015, and the constitutional amendment was, what was the objective of it? That means how the judges, the higher judiciary, the judges in the higher judiciary, that is high courts and the Supreme Court, who are to be the judges, it was to be decided by this particular committee. Are you getting me? What can the legislature do? Though the NJC was declared unconstitutional, that is a different thing. But the legislature has the power to come up with such a law, guiding such a process, thereby doing what? Thereby imposing certain kinds of checks on the other two organs. Clear? The similar idea can also be taken up by the executive. Now, executive does what? Executive can also impose certain checks on the law-making powers of the legislature, like veto powers. The president enjoys, or the head of the state sometimes enjoys veto powers. Like in India, you would find the president enjoys veto powers, and the president has the power to either temporarily or permanently stop a legislation. Even if the law has been passed by the parliament, it goes to the president. The president may exercise his veto powers, and through the veto powers, the president may do what? Would impose either a temporary check or a temporary, what you can say, check on it, or a permanent. That means he might exercise his veto power denying the legislation. Similarly, the executive has the power to appoint judges. Who appoints the members of Supreme Court, the judges in the Supreme Court and the high courts? So the president enjoys that power. President does that. So president also enjoys the power over, the executive enjoys certain powers over the judiciary as well. And similarly, the judiciary also enjoys certain powers over the legislature and the executive, which we call as judicial review. Through judicial review, what is the judiciary doing? The judiciary is exercising control over the legislature as well as the executive. The legislature, when it is enacting a law, the judiciary ensures it is a just law, just law. It is a law which is constitutional. It is not contrary to the constitution. Similarly, when the executive is implementing a law, the judiciary ensures that through judicial review, the laws are implemented in such a manner that it is constitutional. Let's take an example. NJC, I have given you an example. Judiciary declared it to be null and void. Judiciary said, the Supreme Court said that it encroaches upon the authority or the independence of the Supreme Court, and thereby declaring it null and void. Similarly, executive, it also imposes certain checks on the executive. Let's take an example. Have you heard about Rafale deal? कहाँ challenge किया गया था? Where was it challenged? Supreme Court. में there was a review petition on the deal, and though the Supreme Court has dismissed the petition, but if the Supreme Court wanted, and if the Supreme Court found any irregularities with the deal, it could have imposed certain restrictions on the executive. Have you heard about laws with respect to land encroachment? You must have heard about that. There are various laws, and some government land, etc., that is there, you will find that it is frequently encroached upon. In Delhi, I think it was in 2016, there was, what happened was, in the month of December, the railways, it actually evicted certain individuals who were illegally encroaching upon the land of the railways. Okay, it is near Shakurpur in Delhi. It happened near Shakurpur in Delhi. So some individuals had illegally encroached upon the land of the railways. They had put up temporary shelters there. Okay. The railway evicted them because it was December, and because of the harsh winter that Delhi faces. 2 of those individuals died. In the coming 2 days, 2 of those individuals died. And the Delhi High Court took up this particular hearing, that when they claimed that they were not given any eviction notice. There was no eviction notice that was given. There was no such thing. So the Delhi High Court, it actually took up this matter, that was it legal, or should the state had done something else. And after the hearing, the government of India was directed that even in those areas which are facing harsh winters, in those areas, such laws or such laws during this winter time, it should not be implemented. And even if it is being implemented, first there should be some scope of some temporary shelters that should be constructed for them, or that should they should be allowed to stay there, and only then you can evict them or something like that. Now see, if you go strictly by the law, railway did nothing wrong. But see, then despite that, the judiciary does what? The judiciary has specifically directed the executive that this is the way, this is the manner in which you are going to implement the law. Through this, the judiciary exercises certain control over the legislature and the executive. Clear? So the idea of checks and balance, or the principle of checks and balance, was included along with the theory of separation of powers in the constitution of US. Clear? Have you understood this? See, are you getting the reason why checks and balance has been included? Because otherwise, if you implement separation of powers but you do not implement checks and balance along with separation of powers, it has very limited scope of success then. Otherwise, there is no check still on the power of the legislature. Legislature is supreme when it comes to law making. It is supreme as of today also, and hence we are talking about separation of powers. But right now there are some checks that are imposed on the legislature. How? Through executive and through the judiciary, thereby ensuring that the steps taken up by all these 3 organs are not absolute, not arbitrary. They are accountable for what they do. Now there is a check that is imposed on whatever they are doing. Clear? So the idea of theory of separation of powers, if it is implemented in a manner as proposed by Montesquieu, it still would not be so effective. But with the inclusion of the idea of checks and balance, what it does is it ensures accountability and checks on all these 3 organs, thereby upholding the spirit of democracy. Clear? Why am I saying that it upholds the spirit of democracy? Socho, just think over it. Absolutely correct. The idea is always the democratic principle dictates that it is for the people, of the people, and by the people. So a state or all these 3 organs that are there, they do not take up any action which is contrary to the interest of public or public interest. That is the very idea, and that is the reason why when you implement separation of powers along with checks and balance, what you get is the idea which promotes the democratic spirit. Have you understood this? Any idea? If you are facing difficulties, you can ask me. Don't worry. ठीक है? Don't worry about it. ये मत सोचो that who is next to me and because they have understood, I have not, so it's no, I will not ask. Don't worry about those things. ठीक है? If you are facing any problems with respect to what I am trying to say, you can ask me right now itself for the first 2-3 days unless you are comfortable. After that, after the class. ठीक है? But right now for first 2 or 3 days, you can ask me whatever. Have you understood what I am trying to say? Now looking at it from the Indian perspective. ठीक है? Have you understood separation of powers, checks and balances? Absolutely clear. US Constitution of US for the first time. What is the objective? Ensure there is no concentration of power, no arbitrary authority is there. So there is division, and along with it checks and balance. So each organs, they apply some checks and balance over the other. Clear? Now in the next paragraph, write down this, the Indian perspective, very important. The Indian Constitution incorporates the theory of separation of powers under Article 50 of the Constitution. Under Article 50 of the Constitution, since the Constitution provides for a parliamentary form of government, in which the executive and the legislature are not completely separated, the theory of separation of powers is only partially implemented Article 50 states that the judiciary shall be separated from the executive, Further, the Supreme Court in the Kannada Sun versus the state of Tamil Nadu, 1996 case held that the Constitution incorporates the theory of checks and balances. Further, in number of other cases, separation of powers have been held. As a part of basic structure of the Constitution. Underline Article 50. Underline Kannada Sun versus the state of Tamil Nadu 1996 case, and underline basic structure of the Constitution. Clear? let us understand what I have just dictated. See, India is a parliamentary form of government. In a parliamentary form of government, what happens is that, like in India, there are two bodies, the Lok Sabha, the Rajya Sabha. And in the Lok Sabha, how are the members of Lok Sabha, or how is the Lok Sabha constituted? Lok Sabha is constituted by direct elections. That means the whole of the country is divided into constituencies. You must have heard about, every like if I am a registered voter, I am a registered voter from a constituency. So the whole of the country is divided into constituency, and from every constituency we elect one individual to represent that particular constituency. And any political party which gets majority, any political party which which gets the majority in the Lok Sabha, that is the political party from whom we appoint a Prime Minister and the Council of Ministers. Which means the Council of Ministers, including the Prime Minister in India, they are all the members of the Parliament. They are all the members of the Parliament. They may be from the Lok Sabha, generally from the Lok Sabha, but also from the Rajya Sabha. Clear? Which means when we talk about separation of powers dictate what? It dictates that legislature and executive will be separated. But in a parliamentary form of government, this separation is not complete, and the executive belongs from the legislature. Are you getting me? The Prime Minister in India, in India, our Prime Minister, he has a constituency from which he has been elected. So which constituency he has been elected from? Varanasi. So he is a member of Lok Sabha. He is also the Prime Minister. Lok Sabha is a part of legislature, two houses, the Lok Sabha and the Rajya Sabha, the lower house and the upper house. Clear? Similarly, you would find our Home Minister, again, from Gandhinagar constituency in Gujarat, he has been elected. Our Minister of External Affairs from the Rajya Sabha, he has been elected to the Rajya Sabha. Similarly, if we talk about the Defence Minister from Lucknow, constituency in UP. So all the ministers that are there, they are all the members of the legislature. They are all the members of legislature. So in India, what happens, because we follow a parliamentary form of government, and anywhere around the world in a parliamentary form of government, the theory of separation of powers, when it is implemented, it is not implemented completely. It is implemented only partially. And what is that partial implementation? Like Article 50 of the Constitution of India dictating that the executive should be separated from the judiciary. It does not say executive should be separated from legislature and judiciary, because executive is a member of legislature. So it says executive should be separated from the judiciary. Now, have you heard about an office called as the district magistrate? Suna hai na? Why is the office called as magistrate? Why is the office called as magistrate? Do you know what is the meaning of magisterial powers? It means judicial powers. It means judicial powers. Magisterial powers means judicial powers. But does the district collector have judicial powers? Not anymore. Not anymore. No significant judicial powers are there. But he used to have that. Naam district magistrate kyun hai? Why is the nomenclature district magistrate? Because it used to exist. This office of the district head, the district collector or the district magistrate, office is called as the district magistrate because it was founded in the pre-independence era. Now it was founded in the pre-independence era. Going back, this office of district collector has, for the first time it came into being when? Yes, 1772. 1772, you would see that the first this office was created 1772, and during that particular time, not only that the office of district collector enjoy executive powers, it also enjoyed magisterial powers, that is judicial powers. It was concentrated in one office. Post independence, now we adopt for a democratic system. That was something that was going on in the British period, because there was no idea of democracy and all these things. But when we come to the independence era, post-independence era, in the post-independence era, we adopt democracy, and democracy dictates the idea of separation of powers, because as I said, democratic spirit, and hence what we did was the constitution adopted for separation of judicial powers from that of the executive. And today, the office of the district collector that you see, the office of district collector does not have magisterial powers, no significant magisterial power. Even today also, sometimes it acts as a magistrate, sometimes in certain cases it acts as a magistrate. Like during elections you must have heard about, in Varanasi itself, there was an individual who was to contest election against the Prime Minister on the ticket of Samajwadi Party and BSP combined. Do you know his name? Yes, Tej Bahadur. Tej Bahadur Yadav. His name was Tej Bahadur Yadav. Who was he? He was previously in the CRPF, Armed Forces. He actually made a video in which he criticized the armed services for not providing better food, etc., and then he was dismissed from service, and he was to contest election against the Prime Minister. He was to contest elections against the Prime Minister, but what happened? His nomination papers were rejected by the district collector, the returning officer, because when the district collector, as a district collector during general elections, you also are going to act as a returning officer. And who is the returning officer? Responsible for conduct of elections. So when you file nomination papers, you file it in front of the district collector. So when he filed his nomination papers, so the district collector said that because you have been dismissed from service, so you have to, along with this, produce a certificate which is given to you by the election commission, saying that you have not been dismissed on the grounds of corruption. You have not been dismissed on the grounds of corruption, because corruption is a criminal offense, and if there is a proved criminal offense, you cannot contest elections. If you have you cannot contest elections if there is a proved criminal offense against you, you have been held guilty by the court, and you have been sentenced to 2 years or more in prison. So you cannot contest elections then. There is a provision there. Later on we are going to talk about it. So he was advised to bring that particular paper. When he was not able to produce it before the district magistrate, during that stipulated period, the district magistrate did what? As a returning officer, he rejected the nomination of that particular individual. That is what? Judicial power. He is enjoying, he rejected the nomination. Now, that is what? Passing on a judgment. You cannot contest elections. That is a judgment. So he is acting as a magisterial. Some magisterial powers are also there. And that is also the reason why the office is still called as district magistrate. But you would find that since 1972 itself, you would find this body has been deprived of any of what you can say some substantive magisterial powers have been deprived. You must have also heard about a new district level officer called as the district judge. So district judge. Now that office has been created, and all the judicial powers that the district magistrate actually enjoyed has been transferred to that particular office, district judge. Separate kar diya na humne. Judiciary has been separated from the executive. Clear? So if you look at this particular diagram, this particular diagram is not relevant when it comes to the parliamentary form of government, because in parliamentary form of government it would be more appropriately in this manner. On one hand you have the judiciary which is separate, and on the other hand you have legislature, and from the legislature itself the executive belongs. Clear? So more appropriately, this would be a more appropriate depiction of what is the structure of separation of powers when it comes to parliamentary form of government. In presidential form of government, this is not the case. In presidential form of government, this is not the case. Like if we take the example of US, in US this is not the case at all. The president is elected and the president has nothing to, who is the executive, he has nothing to do with the legislature. The president does not attend the meetings of the legislature. The president is not responsible to the legislature, unlike the council of ministers in a parliamentary form of government. Parliamentary form of government, you will find council of ministers attending the meetings of legislature. They are being responsible to the legislature. That is not the case when it comes to a presidential form of government. Presidential form, once the president is elected, the president is no more to attend the meetings, has nothing to do with the legislature. The legislature, even if the legislature, his political party does not enjoy majority in the legislature, still he would remain the president. Like in US, the president basically, does not go to the legislature, and in a year he actually attends the legislative session only once. He is not attending, basically he is just doing what, he is addressing the legislature. It is called as, there is something called as union speech or something, it is called as that. One day he addresses the legislature, that's it. Otherwise he has nothing to do with the legislature. Clear? So you can see in presidential form of government, separation of power is complete. Executive is completely separate from the legislature, and the judiciary. Judiciary has nothing to do with the legislature or the executive. Similarly, the executive has nothing to do with the legislature or the judiciary, and the legislature has nothing to do with the executive and the judiciary. So legislature is responsible for lawmaking. Executive, yes, because it follows checks and balances, so executive has influence over it, but but effectively speaking, executive does not actually enjoy the power to legislate. That power is not there. Clear? That power is not there. So you will find, in president, whenever we talk about the relation between executive and legislature in US, the relation between executive and legislature in US is sometimes, you will find it results into something called as budgetary deadlock. In US, this is regularly the case. Like President Trump has, in the last 3-4 years of his presidency, he has always talked about a wall. You must have heard about, building a wall on the border of Mexico and US. So every budget that he presents, he asks for $2 billion to build the wall, but it is not passed. It is not passed. India mein aisa nahi hota. This is not what happens in India. In India, budget, once it is presented, if the budget is defeated in the Lok Sabha, it means Council of Ministers do not enjoy the majority, and it does not happen. In US, this is frequently the case. So if the president presents the budget, it is not passed. So regularly there is a deadlock, to an extent wherein during Clinton's era, there was a budgetary deadlock which continued for more than 17-18 days. So in US, basically no one was working. All government offices were shut down. क्यों? क्योंकि पैसा ही नहीं था सैलरी देने के लिए. There was no such thing that was going. It was completely shut down. That does not happen in India, because we have executive belonging from the legislature, because there is complete separation there. So there is lot of chances of disagreement between all these three bodies, and that is the reason why you would find they are frequently they are in disagreement, causing this particular problem. Even every president faces it. It's not only Trump. Even Obama, when he was the president, so he proposed something called as an Obamacare, a health care policy that was there. And in that healthcare policy, that healthcare policy, because it was not passed initially. So he had to negotiate with the legislature. Because he was from the Democrats, and legislature then, during his presidentship, legislature was dominated by the Republicans in both in Senate as well as in House of Representatives. The Republicans were in majority, so they were opposing his idea to an extent wherein it continued for around 7 to 8 months. Finally, they agreed to some basic principles, and on which the Obamacare was enacted. This is something that is very frequent there. Yes, they have elections for both. In India, there is only one election, Lok Sabha, and through that we actually elect the Council of Ministers as well. There are 2 elections there, for president as well as for the members of legislature. That is different. In India also we have 2 elections, like electing president, but it is indirectly. There the principles are a bit different. So yes, there are 2 elections. In fact, very recently elections happened. In US, and the Senate, when I say recently, it was about last year somewhere. So Senate was retained by the Republicans, but the Republicans lost House of Representatives, the lower house there. Clear? Have you understood this idea? And this was a case in Kannada Sun versus the state of Tamil Nadu case. The Supreme Court says that yes, in India, separation of powers and checks and balances that are there, it is the part of the constitution. And checks and balances is a part of the constitution. Separation of powers has been mentioned under Article 50, and in various other cases it has been defined as some basic structure of the constitution. Now, what is the meaning of basic structure? Clear? What is the meaning of basic structure? I am going to deal with this idea of basic structure at length, but currently you should understand this. Whenever in terms of constitution, whenever we are going to talk about something called as basic structure, it means the basic philosophy on which the Constitution of India is built. No, basic philosophy on which the Constitution of India is built. And this basic philosophy cannot be destroyed. So any amendment that is made by the Parliament to change or alter this basic philosophy, and if the Supreme Court finds that it significantly alters it to completely change the meaning and destroy the very idea, the Supreme Court declares it to be null and void, which means it is not enforceable. Like in the Ayodhya verdict, if you have read the verdict properly, the Supreme Court said secularism is a part of basic structure of the constitution. This is what is meant by it. This is what is meant by it. In fact, this idea of secularism being the part of basic structure, interestingly, the Supreme Court for the second time has pronounced this in number of cases, but in Ayodhya verdict itself it has pronounced it twice. First was in 1994. We are going to deal with that particular case called as SR Bommai versus the Union of India case. And in SR Bommai versus the Union of India case, it was on the consequences of demolition of Babri Masjid. When it was actually demolished, so what was what happened as a consequence of it? In that case, Kalyan Singh government was dismissed and there were certain things that happened, and the Supreme Court said yes, if there is a government which does not abide by secularism, and any action that is taken by the state government which is against secularism, it becomes a valid ground for their dismissal. It becomes a valid ground for their dismissal, and secularism is a part of basic structure of the constitution. For the first time it was declared in the SR Bommai case, and this time also in the Ayodhya verdict itself, when the Supreme Court was giving that land to the it was giving its decision on that land, again it reiterated that very idea that yes, secularism is a part of basic structure of the constitution. So can India, no, because secularism has been made the part of basic structure of the constitution, so can Parliament of India amend article fundamental rights dealing with religion and right to religion that an individual has? Yes, it can be amended, but it cannot be destroyed, which means like article 25 of the constitution says every citizen of India will have the right to conscience and profess, propagate and practice religion of one's choice. So it can be amended, the provisions can be amended, but it cannot be destroyed, that you completely remove article 25 of the constitution. This cannot happen. Why? Because once it has been declared as the part of basic structure of the constitution, you can only amend it, not destroy it. Clear? So what is basic structure? Anything that has been declared as a basic structure is a part of what you can say, it is a part of the basic philosophy on which, or the basic pillars on which the Constitution of India has been built. No, it is the part of basic philosophy or basic pillars on which the Constitution of India has been built. But it means that, it also means, the consequence of it is that the Supreme Court has come out with a limitation on the power of the Parliament to amend the constitution. You cannot amend anything, or you cannot destroy anything, more appropriately, you cannot destroy anything which has been declared as a part of basic structure of the constitution. Which means what? We have just talked about the power of the Parliament to amend the constitution. We have said that constitution is a dynamic document and the Parliament amends it. But it does not mean the Parliament can amend it in such a manner that it destroys the basic structure. Understood this idea? What is basic structure? In brackets you can just write here. It means some basic philosophy or basic principles over which the constitutional structure has been built. Constitutional structure has been built. Constitutional structure has been built. Clear? Whatever I have discussed under separation of powers, have you understood this? Absolutely clear. Is it absolutely clear? No doubts. Write down a question. Do you think the Constitution of India, does not accept the principle of strict separation of powers, rather it is based on the principle of checks and balances? Explain. Is the question understood? This was the first question that was asked in 2019 mains examination. First question, question number 1 was this, which I have just dictated. Here you go. It is so simple. If you understand the ideas, if you understand the basic ideas that we are discussing, it becomes absolutely simple. There is no problem with this. I have explained this very question. So, does our constitution accept strict separation of powers? Absolutely not. Absolutely not. We have seen that when it comes to separation of powers, if as it was advocated by Montesquieu, We have not accepted it. In fact, the Supreme Court decision, I said underline Kannada-san versus the state of, you are going to write this particular case in the answer. That this case, in this very case, the Supreme Court has declared that checks and balances is a part of the Constitution of India. Constitution, and most of the individuals who were writing mains would have written this answer. They would have written this answer even satisfactorily, because it's a very basic question. But most of them would have missed the case. Most of them, more than 90% of them would not have actually mentioned the name of the case. And this is how you have to ensure. And those who have mentioned the name of the case, at least they would get 1 or 2 marks more than others. So if you want 50%, like if this is a 12.5 marks question, and if you want somewhere around 7 here, so you will have to write the case. Otherwise you get 5. Otherwise you get 5. It is as simple. You have written the answer exceptionally, but you have not written the case, you get 5. Clear? So this was the question that was asked in 2019 mains examination. That is this mains examination that was held very recently. Clear? Have you understood this idea? So it is very simple. Try and write this also. Because I don't expect you to write it very effectively today, because you cannot give those articles etc. that we are going to later on discuss. But at least you should understand it, and you should just give a theoretical explanation if you cannot write the articles. Try and write this. Clear? Absolutely clear? This is what is separation of powers. Clear? This is where I am going to end today, because I will be it's only 5 minutes left, so I will not be starting with a new topic today. So I will be tomorrow when we meet, we start with something called as types of majority first, because again it's like a very basic idea, and if you don't understand it as of today, it becomes a problem. Then we are also going to talk about something called as federal nature of Indian Constitution. And after this discussion, then we move to something called as Article 1, preamble. First we are going to discuss preamble. Thank you.